Hi, I'm Carol Hagberg with Visiting Angels, and I'm pleased today to have William Brown with me. Thank you for coming, William.
Thank you for having me.
Yes, you're welcome. He's an independent elder law attorney. So, first question everybody seems to want to know is, what does an elder law attorney do? What is elder law?
Well, elder law covers a lot of different disciplines. And you could probably say that we help individuals and families with near-end or life-ending legal problems. And the area that most elder attorneys work in is long-term care planning. So you'll find a lot of us working with people who want to get on medical assistance, people who have some estate planning work they need done, people who are cognitively disabled and may need a guardian or may need a conservator. I also do some vulnerable adult counseling for people. People who feel that they are being financially exploited may come to me with some help. So those are some of the areas that are under the umbrella of long-term care planning. But it can be, I also work with people who are not seniors. I've done trusts and things for people who are in their 40s, people who are in their 50s. I've done some work with veterans benefits through the AIDS and Attendance program. I work with about 3 financial planners here in the Twin Cities, and we try to help them get on the AIDS and Attendance Veterans Benefits program too. So it's a lot of different legal areas, all encompass elder law really.
So not necessarily just the elderly,
No.
but it's planning for that long-term care?
Yes.
At the end of life?
Yes,
Or,
you sit down with a person who's thinking about medical assistance. However, they want you to review their will, or they don't have one, or they want their assets to be preserved for their kids and grandkids in a trust, or there's a veteran. So when I start off with just doing medical assistance, it always branches off into all these different legal areas.
yes, and you, what is really helpful, I think, to the average person is to know that they don't have to have a lot of money to be able to need an elder law attorney. You really need someone to help you kind of navigate the systems and know what is available for what level of income you're at or what level of assets you have.
That's correct. It's trying to navigate that maze on your own. It can be very confusing for people. Not that there aren't people who can do it without an attorney. You can. However, you could be stepping into some legal landmines, and it's probably better to hire someone that understands the navigation through the medical assistance statutes that we have.
Right, right. Just like we wouldn't use do complicated taxes without an accountant.
Right.
Same sort of thing.
Right.
There's a question about spend down. How does that relate to medical assistance?
Well, there are asset limits and income limits or income qualifications that you have to be on the medical assistance program. So when you visit with a client, you might do some sort of asset assessment to see how much money they have and what their assets are: home, car, stocks, CDs, etc. Well, if you're a single person trying to get on medical assistance, you can only have $3,000 worth of assets. So if you've done what you're supposed to do in life and save in your 401k and invest, then when you get to be 65 or so, you have a lot of money. But then you get sticker shock when you go to a nursing facility or an assisted living facility and realize how much money you're paying per month for yourself or your spouse. So the county will say you have to, quote unquote, spend down to reach whatever limit you qualify for. It can be $3,000, $6,000 if you're married. And I help people try to purchase what's considered maybe exempt assets that the county will not count as an asset when you're filling out your application. Or if there's a mortgage on your home that needs to be fulfilled, you could pay off your mortgage. There are some things you can do to start spending down to whatever limit, either 3 or 6. So that you qualify for the program.
And it is a way of protecting your assets
Yes.
as much as you possibly can. for a spouse who might not be needing it at the time,
For a spouse, for yourself?
or for yourself?
You could do both. Either the state will also allow you to purchase some exempt assets beyond your spouse and yourself. You could buy burial space items for your children. There's no limit on that.
Okay.
But once again, you probably need to chat with an attorney that knows what is exempt
Right.
from what isn't exempt.
Right, exactly, because they do, when you're trying to qualify for this program, they'll look back, 5 years at
Yes.
your spending, and then try to maybe recoup what was spent inappropriately according to the program.
That's correct. The 5-year look-back period is really for uncompensated transfers. The way the idea behind Medicaid is that it was set up to help people who are low income pay for health care costs. But when you have middle-class people who are trying to get on the program set up for lower-class people, then they're caught in this situation. They save their money. However, the county will say, well, if you have uncompensated transfers within 5 years of the date of your application, that will kick in some period of ineligibility. Once again, probably needs to talk with a person who understands what you can gift, what you can't gift, when you can do it, how much you can do. Well, supplemental needs trusts are set up for people who are trying to put aside money as secondary to what the government is giving them. A special needs trust is set up for your own benefit with your own money. So it's the Medicare or medical assistance will allow special needs and supplemental needs trusts as exempt assets.
Okay.
And you can put as much money in there as you like. But to set up like a regular inter vivos trust, just a regular garden variety trust, the county will say that's probably not going to fly with them. So you're not going to be able to get on the program. You've set up just a regular trust.
Well, I can see how complicated it is, so it is definitely necessary to get an advisor, an attorney to advise on that. You also talked about working with guardian, conservator. I know there's the power of attorney term out there. Kind of to explain the differences of some of those.
Well, when I do an estate plan for people, I just did one for a man this morning, and I asked him if he had a Health Care Directive, and he claimed that he didn't. When you set up an estate plan for people, typically I try to give them their will with a power of attorney and a Health Care Directive. Powers of attorney, a durable power of attorney states that when an individual is incapacitated, you're going to allow an attorney, in fact, a different person to handle your finances for you. A Health Care Directive is pretty much the same thing. The difference is it governs healthcare decisions. If I'm unable to make healthcare decisions, I will have a healthcare agent make those decisions for me. The difference between those two in guardianship and conservatorship is the first two have no court supervision. A person can go into the hospital room of their loved one, have them sign it, and do what they want with it. That's why it's probably coming under a lot more scrutiny than a guardian and conservator. Those are court
Appointed
supervised
okay.
hearings. So you have to petition. There's a physician statement that comes along with that. There's well-being reports that you do after the guardianship or conservatorship is in place. So this is probably a bit more safer for people to do the court route. Although I run into a lot of people who just want to do the power of attorney. It's quick, it's fast, it's not as expensive. But if there are problems, you really want a judge to come in and review the case. And it's probably safer to have a guardian or a conservatorship hearing.
When I've been working with guardians, conservators, it normally is in a situation where there is some family dynamics that don't allow decisions to be made for a loved one. Now, also remind us, what is the difference between a guardian and a conservator?
Well, like a power of attorney, a conservator handles the financial part of the estate for the ward, and like a Health Care Directive, the guardianship handles the health care decisions of the ward. So they're a little bit different in that regard.
One is financial, one is health care.
Correct.
Right. Another thing, besides getting a power of attorney or guardian, you know, the difference is, I know that families also do that, go to the court-appointed, court-monitored guardianship in a family where there is a large family, and so they don't have to worry about any conflicts because they have turned it over basically to an outside party who can then gather all the information and then be able to, you know, collectively make a decision without hard feelings. So big families have done that too.
That's another safe route to take. One of the problems that I've seen is if you try to have multiple guardians and multiple conservators who are in the family, inevitably you will have the brother and sister not getting along or some issue. So sometimes it's safer to have an outside party come in and be guardian conservator for the ward. It can make things a lot easier.
Yeah, I agree. So is there anything else you'd like to tell our audience before we go to?
Well, yes. The issue that I come up with quite a bit is when I lecture in the Twin Cities as well. And people will not make these decisions immediately. They tend to make these decisions when their family member is already at the nursing home or at the assisted living facility, and there isn't the proper medical assistance planning. So if I can press upon people in your audience, it would be, if you're listening to this broadcast, try to get the ball rolling while the person is cognitively able to understand. Please don't wait until they've already had the accident or they're already in the facility and then try to take care of these things. It could be too late.
Right. I like to say too, it's always good, you know, at any age, we should each have a power of attorney who is there in case something drastic happens, that we aren't able to make our own decisions. So I think that's a great advice. So thanks for joining us again today. If anybody has any questions, just give us a call and we'll be able to connect you with William. Thanks for joining us.